issues, right, saying, well, I started in the post office, so I'm not going back.
It's just an conversation.
Well, traditionally, people say here are all our exhibits, and they're numbered, so everybody doesn't ask for them to come back, and it's hard to keep track, especially in this case.
Sure. We'll get that fixed. Thank you.
Thank you.
Good to see you.
Right. So, the attorneys have an opportunity to talk over the break about the renewed motion for dismissal for fraud on the court.
We did, Your Honor. And we actually think that I'll take a photo. We actually think, Your Honor, that the concern that you raised this morning is probably correct. We think you were probably right on this, that while the recusal motion is pending in the other case, and that this motion involves the complaint that was filed in the other case, it probably is not a motion that you can hear today and would refer that, I assume that either, you'll make a decision on the other one, and it'll either be you on both of them, or it'll be referred, the other case, and presumably this motion would be referred to a different judge.
So, let me ask plaintiff this. Mr. Bowe, are you filing a response in the other case, Mr. Turkel? I'm not asking you about your response.
Yes.
Okay. So, then from a timing perspective, I'll enter my order within the 30 days. Would the parties, based on the results of that order, would the parties, if it is, just never mind. So, never mind.
You're going to ask us to game out a bunch of things that's hard to do, I would imagine.
Well, so often we consider things under the administrative order by written submissions. So everybody's already supplied written submissions to this, so we can just wait and see how it falls.
Judge, we should have our response in opposition to their motion to recuse. We got a little sidetracked with everything today. We should have that filed maybe late next week.
I'm not asking you for time frame.
Yeah, I'm just gratuitously volunteering it just so you have some idea. But there's one point I'll go ahead and make just for the court's consideration, and I don't think we should make a decision on it today. Because again, this just dawned on me, like I informed the court earlier as I was preparing last night. I kind of put it in the margins and said, wait a minute, we need to address this issue of the other pending motion in Bolea 2. But in talking, Kristen Norris is with this judge from Kynes, Martin, and Feldman in Tampa, and in discussing it, we think there may be law that says if the motion for fraud on the court were otherwise accepting all of the contentions in it is true, facially, legally insufficient, that there's, in other words, if you assume everything that they've alleged, which really it's only different from the previous two in the sense that it cites to the new complaint. That's the change. In other words, this is the same motion for fraud on the court they filed twice. It's already been ruled on twice, but now they add in the allegations of the new complaint. Arguably, under that scenario, you may be able to rule. I just haven't been able to grab any law by now.
I think it's a hot potato.
Okay. I just wanted to throw it out there. I generally would agree with that, but I didn't want to not say that, knowing that there may be some law out there that basically would allow that. But is the plan then, Judge, to await our response, rule on the motion to recuse in Bolea 2, and then, depending on how that works, we'll address this afterwards? Does that sound like what we're agreeing on here?
don't, but there's agreement. I would say I think that's appropriate.
That's, okay. Yes, whether there's agreement or not, that's how we have to handle it. And I would only say this, that I guess, depending on what happens, if this, maybe we should get a hearing date or something, just have it out there.
We'll see.
Okay.
Okay. All right, so I think then that next on the agenda takes a while to come to plaintiff's motion for entry of judgment and permanent injunction.
And I am going to be brief, Your Honor. I think the parties have documented their positions fairly well in the moving papers. The final judgment itself, I think, is the standard form. It includes the rulings on the fact information sheet. The real issue, I think, is the parties' disagreement over the entry of the permanent injunction, and number one, whether it should be entered, and number two, whether or not it's overly broad. We think the evidence at trial established, obviously, all the factors the court needs to review in order to enter the injunction. We've included detailed findings in it. One of the arguments that's been made is that they're too detailed, which seems to conflict with the issue that the second DCA had at the preliminary injunction phase, which there were not enough factual findings. But given that the court also has to, under the constitutional facts doctrine, conduct an independent review of the record as a whole of the jury's findings there, we think that this form of the injunction, fills that purpose as well. Obviously, there's not a lot of case law on permanent injunctions in these types of situations. There's none specifically on point. Both parties have sort of cited some law saying that the court has the ability to prohibit conduct and doesn't. I think really the easiest issue here for the court is that with the jury's determination, if the court agrees with that determination for the purposes of the equitable relief, that footage of Mr. Balea that was illegally recorded that shows him engaged in sex or naked, explicit footage, if it's not newsworthy, which it's not here, then to publish, disclose, disseminate that footage would be a violation of Florida's video voyeurism statute, and it would be a violation of the Security Communications Act to disclose any of the audio on that. We cited law to the court, the Mid-American case, where the court can enjoin criminal activity. So we think that that would justify the entry of the permanent injunction. We think the scope is limited. We revised it subsequently to try to make the scope limited. Essentially what this injunction does is it just prohibits the Gawker defendants from publishing online or anywhere else explicit footage of Mr. Balea that emanates from illegally recorded video of him. So we think that under the facts and circumstances of the case, that injunctive relief is warranted. There's an argument that's been raised about, well, the injunctive relief here isn't necessary because the punitive damages were awarded in order to deter conduct. And I think in that instance, Judge, it's important to look at the post-trial comments that have been made by the Gawker defendants. You had a punitive damages award entered. One purpose of that is to punish, which obviously an injunction doesn't address. It obviously didn't have a deterrent effect because they immediately went out and said, we would do it again, and I have no remorse over what we did. So we think on that basis, Judge, that the court obviously would be entitled to enter this permanent injunction. We have included, obviously, record sites. We have trial transcripts if the court wants them. It is an extremely detailed permanent injunction, but we think under the specific facts and circumstances of this case, and given what's at issue, that it's well warranted.
So you said about a revised permanent injunction?
The one that is in your notebook should be the separately tabbed item.
Could you just check it?
Yes. This is just the final judgment, Your Honor.
Oh, so you're going to hold on just go. Hold on just a minute. It's just the next step.
Your Honor. And we also provided a disc with Word versions of the final judgment and the permanent injunction. The version on that disc is the revised.
Right, okay, great. Thank you.
Thank you.
Your Honor, let me, I think there's two pieces to the motion. One is the motion for entry of judgment, and one is the injunction. And I'm going to let Mr. Saphir talk about the injunction if I could, but on the judgment, I don't have any issue with the form of the judgment, but I did want to say this. If we still have a motion to dismiss and a motion for a new trial pending, I'm not sure that we can enter the judgment just yet. We might have to hold actually entering the judgment until that is adjudicated, which I assume would be soon, but, and I don't have any problem while we're here agreeing, with you. I mean, I object to the judgment and preserving all our objections, but as to the form. But I did just want to make that point, and I think we probably have to hold that, that part of it until the motion to dismiss is adjudicated. I don't think we can enter judgment while there's still a pending motion. That's all I wanted to say, and then if it's all right with, if you have questions about that, I would let Mr. Saphir talk about the injunction.
So, Your Honor, just talking about the permanent injunction piece of this, in our opposition, we laid out the core of our argument. You've read it. Some of that has since been overtaken by events, since we incorporated by reference the Ritter arguments and the JNOV arguments. So I just want to focus on the part that's still live here. As Mr. Vogt correctly stated, any injunction you issue has to be based on your own findings, not the jury's findings. The three prongs of the permanent injunction test are there has to be a violation of a clear legal right, showing of irreparable harm, and a showing of a lack of an adequate remedy at law. For the first prong, you know our position. We don't think there was a clear violation of legal right. You will do what you do with that. I want to talk about the other two prongs a little more specifically. On irreparable harm, I don't think there's a threat that we're going to repost this. We took down the video excerpts in 2013. We could have put them back up. We didn't. On the issue of lack of an adequate remedy at law, that's our argument about punitive damages. And we do cite cases on this, Your Honor. The representations to the jury about punitive damages were, you need to bang them with a big punitive damages award to deter them from doing this. They did that, right? And that's the purpose. And there are cases that say you choose. You get punitive damages or you get permanent injunctive relief. What Mr. Vogt said in response is, well, Nick Denton, A.J. Delario went out in the world and said these things, and so clearly there's no deterrent effect. Respectfully, whatever one thinks of what Nick Denton said and what A.J. Delario said post-trial, they're not saying that they're eager to go post this thing again, right? What they're saying is they still believe it was newsworthy. Their position hasn't wavered, that they believe they had a right to post it initially, and we'll see how the process plays it out. I don't think there's any suggestion that they're going to go back and do this again. And Nick Denton's allowed to make statements.
You said you don't think.
All right. There doesn't seem to be. I don't think that's a fair reading. I don't see how you could read that as anything but someone saying, look, our legal position hasn't changed. I don't see how, I don't see that as a threat to repost. And I certainly don't see how anyone could, is how I'll phrase that, but perhaps I'm wrong. So that's the issue of a permanent injunction at all. On the second issue of the specific permanent injunction relief that they're seeking, our position is laid on our papers. We think this is overbroad. The cases they cite, and they're correct on these are good cases. They're cases that go the other way, but let's assume that their cases, one from California, one from Minnesota, are controlling. What those cases say is, look, you can almost never get a prior restraint, but if there's a trial, if you adjudicate, the specific speech or publication that's been challenged, after that adjudication, you can join that specific speech. And that's probably right, or at least, right in some context. But they're asking for more than that, right? They're asking, what?
They're asking for the 30 minutes.
Yeah, they're asking to enjoin anything that could conceivably be published from that 30 minutes, and you just can't decide in a vacuum, right? Mr. Vogt said, we're not asking, or that they would not, Mr. Vogt said because of findings about the nature of the recording, they would be confined, the only thing you can publish, out of 30 minutes is something that was newsworthy. Well, we don't know whether it's newsworthy or not. We had this debate, earlier today. Is it objective analysis, a subjective analysis? At the very least, we know there has to be a publication to make the, newsworthiness analysis. Here, there's just source material. I don't think you can enjoin any conceivable publication that might come out of source material. Again, I don't think, there isn't any desire to publish anything from the 30-minute sex tape. But I think an order that broadly enjoined anything from the 30 minutes would be blatantly unconstitutional. And the final point, Your Honor, has to do with the findings. Mr. Vogt is correct. This court does need to make findings in support of the injunction. But the law is clear that the findings need to be tied specifically, or need only be tied specifically to the three prongs that we talked about. So they have proposed findings about economic damages. Don't need to reach that. They have proposed findings about the written commentary. I don't think you need to reach that. They have proposed findings about things that were said on Slack or Snapchat or what. I don't think you need to reach that. So that's all our point there, is that we, as we say in our papers, we vehemently disagree with their characterization of the facts, but we don't think you really need to get there because we don't think you need to decide all the facts they're asking you to decide, even to grant them injunction relief, if you are so inclined, Your Honor. Thank you very much.
Just very briefly, Your Honor. The fact remains that they have footage of him naked and having sex that was illegally recorded, and nothing currently prohibits them from publishing that. You brought up the point, well, you don't think they're going to publish it. Well, the parties we're talking about are the same parties that before a jury, begged attrition and said, we've learned our lesson, and then immediately turned around the next day and said the exact opposite. With respect to the 30-minute tape, we're not saying they can't publish anything off of that. What this permanent injunction relates to specifically, and very limitedly, is explicit footage of him naked or engaged in sexual activity. Either video or audio, but it's limited to that explicit footage, which under Florida law would be a crime to publish anyway because this is not newsworthy. That determination has been made. The 30-minute tape is the tape from which the excerpts were derived. So that determination has already been made, and obviously the court has seen that footage. The one final thing is that with respect to the statements that, well, they have no intention of publishing it, one of the things you do is balance the potential harms in an injunction, and if that's the case, then what they're essentially saying is there's no harm to us because we have no intention of doing this. So we think it's well supported. Thank you, Your Honor.
All right, thank you. All right, so I will address the injunction aspect of it at a future time. Plaintiffs who need motion to compel, request for ruling on claim of privilege associated with the transfer pricing study. This one was a little bit confusing because the defense said that they had sent the order back in December. I did not have the opportunity to go back through the docket to see what kind of an order. It seems, though, that there were three parts in that proposed order, and one of the parts which referred to the trust information in London had already been addressed. So I thought that this order had been signed.
Your Honor, it was not signed. I believe it was submitted by the plaintiff, not by us.
But I just got it from you all. I mean,
Yeah, we had attached
you
it.
had sent it as a copy.
We had attached it now, but it was back in December. It was filed by the plaintiff. And you are correct, it was a later order. This order was never signed. So it was a later order that sort of followed on this order that dealt with the discovery in the UK. That was the issuance of the letters rogatory. And that's actually the thing that then proceeded, and those were taken care of. But that's actually a later order that was actually signed.
So this particular order, part of it, I think, is outdated, right?
Yes, and I mean, to the extent that it memorializes a ruling that Your Honor made, no, but otherwise events have overtaken this order with respect to that, absolutely.
Anybody else have anything they want to say about this particular sign, whether I sign or not sign this order?
I think probably what we would do, well, I think it's fine to enter this order, since most of it's already been done.
Well, I would like to just speak briefly. I mean, Mr. Bode's motion, so if he wants to go first, it's fine. I would like to just speak briefly to the question of whether or not the trial's over, it's still warranted. That's a separate issue from what happened back in November, I think it was. But if he wants to go, if it's his motion, if he wants to speak first, I'm happy to take my turn.
I think we've stated our position in the papers, and if I need to do a rebuttal, I will.
Very briefly, Your Honor, let me take the podium here. The order, what happened here in this motion was, with respect to this particular document, we had produced, as Your Honor knows, a great amount of financial related discovery from Gawker, including a whole bunch of information about its relationship with its sister company, Kinja, over in Hungary. And the piece of it that this concerns is royalty payments to Kinja. And we had produced the license agreement that deals with those royalty payments. It's attached to the motion that they filed. We had produced I think we had produced all of the bank statements that showed each of the payments, literally individual payments, so they would have all this information. And they came and they said, well, we want, for purposes of making our damages arguments at trial, we'd also like to have this report that was prepared by the Mayor Brown law firm. And we objected in a privilege log and said that's privilege because it was prepared by a lawyer, gave tax advice. And generally speaking, you have the data, you know, all of the payments, you know how much was paid, so you could make whatever arguments you want to make. They objected to that assertion of privilege and brought their motion back in November. And Your Honor, at the hearing, was prepared to originally said, yes, I'm going to deny the motion because I find that that's privilege. And Mr. Turkel raised this case called Summit Bridge, which we submitted, saying in-camera review is required. He said, you know, we don't know what it says because we haven't seen it. It was just raised today for the first time. We went back afterwards and looked at the case, and it actually doesn't say that. It says that if you were going to order the production of something that is a trade secret, you should look at it first to make sure you're not invading somebody's trade secret. It doesn't say the opposite, which is if you're somebody's asserting privilege, you always have to have in-camera review. So our basic position today is, number one, Your Honor had it right the first time back in November, and that had we had the benefit of actually having this decision to look at, we would have been able to demonstrate that legally, and that factually, the premises of taking that discovery at that time was for purposes of trial. Now we're in a situation where we don't have, it's really, you know, it doesn't really relate to anything. We don't have a judgment. We don't have a bond where there's a question as to whether it's been improperly reduced and all of that. And we may get there, but we're not there now. Number one, number two, and number three. If the even if we did get there, it really doesn't go to the question of that you could get sort of post-judgment discovery. Either is the bond improper, or do we need this for collection? And in particular, the issue with Kinja is, we had this whole back and forth with Kinja in this case, and the plaintiff wanted to defer the trial with respect to Kinja on his alter ego theory until the second trial. And Gawker, concluding that the only thing that might be worse than one trial of this case would be two trials of this case, said that we object to that. That was appealed, and the DCA said, no, if you're going to raise the alter ego theory, you're going to do that all together in the first trial. And we then said, okay, fine. And then the plaintiff, in an effort to keep the trial date, or remember this, said, okay, we're dismissing Kinja with prejudice. So having done all that, and having had the opportunity to go down this road with Kinja and decided, no, they're not going to do that, it would sort of completely undermine all of that that's already happened to come back and say, now we want to do that, even in the post-judgment context, even assuming we had a judgment or a bond that it was related to. So that's really what I wanted to say about this. unless Your Honor has any questions, I know you said it was a little confusing, and I think that was just over the procedural history, but if there's anything in what I just said that you have questions about, I'm happy to answer.
Well, I understood the procedural history. I mean, the confusing aspect of it was because I believe I'd already addressed some of the issues in the proposed order.
Oh, the other things, yeah,
I
sure.
guess the other aspect of it that I think you really want to address is, had the order been entered back in December, or whenever it was, and the court conducted the in-camera inspection, and the plaintiffs had that information or didn't have that information prior to trial, that's one situation. But I think here we are now, post-trial, and I think really your papers really more address the timeliness of it and your objection to the timeliness of it at this point in time, right?
That's a significant, I mean, basically, we're saying that it's not needed now, because there's nothing that it's related to, and we're also saying that, you were right the first time on the privilege issue. So those are really the 2 points in the summary.
So I in reviewing it all and reviewing the case law, I think the in-camera inspection would be appropriate. The issue that, if you want to address any additional or the plaintiff, is the timing of it at this point in time.
Right.
It's sort of a two-part
Right.
phrase.
I mean, this sort of dovetails in the other motion, which asks for discovery right now.
Right.
There's nothing that we have to take discovery on. We don't have a judgment, we don't have a bond that's been asked for or reduced. All of the things that you would get that for, we don't have, so it's premature, and that's really...
Jumping into the next section.
Yes, but that's really it dovetails, so I just wanted to flag that for you, but yes, exactly right.
Okay. Anything else you want to say that?
No, Your Honor.
Okay.
Thank you.
Vote.
Do you want me to go ahead and just start dealing with the next motion too? Because I think it's
I'm sort of already there.
interrelated.
Mr. Berlin, I don't think wanted to go along with me, but
Yeah.
maybe he just said his point, so go ahead.
All right, so the main argument they're making is that it's premature at this point to do any of this discovery, and we obviously disagree with that. Rule 1.550 says that upon entry of the final judgment and the denial of any post-trial motions, the post-trial motions have been denied at this point except for the one lingering issue, that execution issues. At that point, we're entitled to discovery and aid of execution. That's one issue. The second issue is we are entitled to discovery regarding any request that they're going to make to reduce the amount of the bond. Their financial condition is certainly at issue. The whole point of a bond is to make sure that the party prevailing at trial is protected because he's denied the opportunity, if a stay is issued, to actually go out through collection activity. Essentially what they're saying is, well, don't do anything until we file our bond motion. Well, by then it's going to be too late to get the discovery so that we have it for the hearing that's going to need to be set. It's going to be a very fast process. I mean, they're going to have to appeal quickly. They're going to have to ask for a stay quickly. And we should be entitled to get this discovery on an expedited basis, so when we come into the court on what is inevitably going to be their request to reduce the amount of the bond or set a lower bond than the total judgment, that we have the facts and evidence necessary to address that. The court, in setting the bond, has the right to set conditions on that bond. It has wide discretion in setting those conditions. This discovery can be one of them. You're in a situation now where, and we've put this in our papers, but you've got investors that have already come in and taken ownership interest in the company. You've got rumors about additional investors potentially coming in. The terms, at least of the one that we know about that have been publicly disclosed, are not great, potentially harming our client's interest and ability to collect in the future. So when you take those things into consideration, we should be able to at least get the ball rolling on this discovery. The third issue is that under 45.045, in the event that there is a reduced bond amount set, or it's capped at $50 million, that's an issue that will probably have to be addressed. We're entitled to discovery to see whether or not they're dissipating or diverting assets, and that's directly what this is related to. So we'd like to get that ball rolling sooner than later because these things are going to happen in the very near future. Thank you.
Did you have anything else to say?
Very briefly, Your Honor, I think I made the principal point that I would make with respect to this, which is that, we don't disagree that at some point, if there's a judgment, and if there's a motion for a stay, and if there's a request to reduce the amount of the bond that would be required for that stay, they may be entitled to some discovery, right? We're not there yet, and the rule is very clear about the sort of order of battle, and the court, we would respectfully request to follow that order of battle that's set out in the rules. The statute on this is pretty unambiguous in terms of saying that only after an appellant has posted a reduced bond, the appellee, and it refers to people in terms of appellee and appellant, so that there's already an appeal pending and a stay.
There's a couple already, I think, still in your opinion.
Not the end of the case one. So, and then the same thing is true with the rule 1.560 with execution, which is you have to have a judgment before somebody comes. And generally, you would come and say, before you say I need a bunch of discovery, you would have to come and say I've tried to collect this judgment, I'm having trouble, and here's the discovery I would like to take. The second thing I would like to say is that a generic request, can I take discovery in this instance, is really not what's contemplated by the rules. The rules are contemplating specific discovery that goes to the question of whether, with respect to the bond, there's dissipation or diversion of assets. With respect to execution, here's what I need for execution. That is made worse by the issues with Kinja and GMGI, who've been dismissed for different reasons from the case. I already alluded to that. I won't allude to it again. And also with respect to third parties, where there's a specific procedure that says, come, enumerate the discovery you want. We can object. Your Honor would resolve any objections that we can't do amongst ourselves, and then they can serve that discovery. So a carte blanche, can I take discovery request, is really not what's envisioned at this stage of the proceedings. And what I would say, and I said this on paper, so I'm just echoing this, which is that if we got to the point where this is all proper, we would agree that they might well be entitled to some amount of discovery, and we would work with them to try and work out what that is. That's not to say they're not entitled to discovery at that point. What we are saying is that an open-ended carte blanche, you can take any discovery, and you can take any discovery you want from these 6 entities and individuals that are listed in their motion papers without following the rules, is not what's envisioned, and that's really our point.
I'm inclined, though, to Mr. Berlin, so this is what I want to talk to, is on this, the issue of the in-camera review. I signed this order. You then supply the information to be reviewed, so at least that gives me some time so that at whatever our next hearing is, then that part's already done. Do you have any thoughts with that?
If Your Honor is inclined to review, we obviously object to that because we think you had it right the first time, which is that it's privileged because it's tax advice, but Your Honor wants to review it, and if that's what your decision is, yes, we should give it to you so that you have adequate time to do that, and if Your Honor is going to then overrule the privilege, what the order there envisions is that we would get a brief stay so that, because it's a privilege issue, if the client wants to, they could seek appellate review.
I was taking that in 2 separate parts. That was one part, the financial discovery, and the
Did you want to talk about the other section? Was there other questions that you had about the broader request for?
No, I was just looking at those 2 requests
in different ways, yes, Your Honor. There is one there is actually one piece of discovery that I do want to raise that's actually discovery that we would like to have, Your Honor. It's not about post-judgment finances, and it's admittedly a little preliminary, but within the last 24 hours, Your Honor, there have been news reports, one in Forbes magazine and one in the New York Times, about a Silicon Valley billionaire named Peter Thiel, who is apparently been funding this litigation, unbeknownst to us, for some portion of the last almost 4 years. We believe that this potentially relates to our efforts to get post-trial relief, as well as the questions that may come up on a bond in terms of whether there is been a satisfaction of the amounts paid. If the amounts are secured, we don't know whether Mr. Teal is just paying for defense. We don't know whether Mr. Teal has promised Mr. Belay some amount of money, and we would like to have a limited amount of leave from you to try and get to the bottom of that. And it is, I'm happy to hand up the 2 articles so that Your Honor's not just taking my word for it, but this is what we're basing it on. Normally, if this hadn't been arisen in the last 24 hours, I would try and gather a little bit more information and bring it to your attention, but I know we're all interested in trying to reduce the number of additional hearings in the case, and so I wanted to raise it with you and let you know that this was afoot as soon as I knew. And let me
I'm
just...
not really clear what you're saying. So you're saying there's some newspaper article or news article out there that Peter Teal is funding the litigation for the plaintiff?
That's correct, Your Honor.
Okay, so how would that affect any final judgment against the defendant?
Well, it's hard to say, Your Honor, right? We don't know exactly what the nature of the arrangements are, and that's why we'd like to ask the discovery. But if we're...
Is that sort of good with the goose, you know, the goosey gander rule? I mean, I'm hearing them say, let me get some little
Well,
discovery because we know these other investors that are coming into the defense, and now I'm hearing you're saying you maybe want some limited discovery because who's paying for the plaintiff?
Right, but that one is related to one is related to collection of the judgment or the bond. One is related to whether or not there's something that happened improper in the case itself, right? So that's what we're trying to find out.
Well, I don't know. I'm not sure what you're asking for me for right now.
I mean, for what it's worth, Your Honor, maybe I can suggest this, which is just so that you have them. I'll hand up the 2 articles, and that and that happens here.
Some of these kinds of articles have been floated around in past against the defense, and anytime they get brought up before the court, there's somebody on the defense side hopping up and down going, oh, no. So, it's that goose and gander rule again.
Right. I just mostly wanted the court to be aware that this was an issue because it is something that, there may be more information that comes to light in the coming days, and I just don't know. But we would like to be able to get to the bottom of it because it's obviously we're facing now, imminently a judgment of $140.1 million. It's serious business, and we need to make sure that before that happens and there are serious consequences to the defendants, that we understand the full ramifications. We sent discovery requests that said, tell us all the people that you talked to about this case. Never heard of this guy before. It seems a little bit weird to me.
Well, I don't know, but at this point in time, I would say when you have something, then you'll bring it to my attention.
Well, it sounds like since we're otherwise going to put off the other discovery, we'll do that. But let me just, while I have them, if you don't mind, Your Honor, if I can hand these up.
I don't know that I want to see it. I purposely try and not look at all that information. I know there's information that's out there that floats, that periodically some waif of it comes by me, and I purposely do not look at any of that kind of stuff. I like to just stay strictly with what I see, which both of the parties have given to me and both sides know. So I just do not have it unless it comes in some form and I'm supposed to be looking at it. I don't like looking at all the stuff that's published out there. Sometimes not healthy.
I understand, Your Honor, and I'm not trying to get you to just base, and I'm going to be clear about this. These are news reports. Normally we would come with, something, but this is in the last 24 hours. Both of them were published yesterday, and so admittedly I'm a little bit, but I wanted to make sure that we were bringing it to your attention, and it is of concern. And just to say one last thing, which is it is of concern because the allegation is that, and this is part of why I think it's important to get to the bottom of this, is that the allegation is that Mr. Teal is sort of funding a campaign against Gawker in multiple lawsuits, this one included, including other places, all brought by Mr. Harder, who's unfortunately not here today. But the concern of a Silicon Valley billionaire trying to use litigation in many places to try and inflict pain on Gawker is obviously of great concern to Gawker, and something that we do think it's appropriate to try and get to the bottom of, if not now, then at the appropriate time.
Okay. Or it may not even be here, so we'll wait and see.
All right, very well, Your Honor.
Thank you. Okay, so then, is there anything else that we need to resolve today?
Judge, I want to give you a citation on whether, and maybe it can assist your staff or whoever researches.
My staff?
Yes. No?
Okay.
On the issue of whether this motion for fraud on the court would stay entry of judgment. whether there is a case, Ms. Norris, and I haven't introduced you to Kristen Norris, Judge, but she's with Kynes, Markman, and Feldman in Tampa, and is appellate counsel for Mr. Balea, or putative appellate counsel, I should say. Hazen versus Smith, Your Honor, 101 Florida Reporter, 767. It's an older case, but just sort of on the fly as some of this was happening today. The court found that a pending motion for new trial does not per se stay entry of judgment after verdict in a proceeding at law, nor proceedings by execution thereafter to enforce such judgment. This is true whether the motion for new trial stands over from one term of court to another or not. I think it's important that perhaps we find out as a matter of law whether their revelation that the motion that they filed in conjunction with the other motion in Balea 2 prohibits you from hearing it, whether that stays judgment or not. And I think it's probably a good exercise. We'd be happy to submit some papers on it because there is no timeline, and we did get a verdict, and we do want judgment. So
Well, you're welcome to supplement. Both sides are. I know you said you were supplementing the other motion, and you were hoping to have that to me on Monday. So if any side that wants to supplement that aspect of it by 5 o'clock on Monday would be great.
thank you, Judge.
Monday is,
Oh, it's a court holiday. Thank you so
Tuesday.
very much. I'll be working, but yes, Tuesday would be fine.
Judge, on this other issue Mr. Berlin raised, I'm going to say one thing and one thing only, and that is whether litigation funding occurs or not, it's addressed by the Florida Bar Rules of Professional Conduct and happens all the time, and I don't think there's any discoverable information ever in there. But whatever they intend on filing, I can't imagine what it is, but we're going to look at it with a very sharp eye towards whether there's anything or any basis to ever do that. And I have no idea what they're going to do. But at some point, Judge, we have to take some action, we meaning the plaintiff's team, to try and de-incentivize this constant barrage of ideas that get vetted in here because Mr. Berlin may see a newspaper article, okay? We have a verdict. We spent an awful lot of time getting that verdict. And what's that? Yes, Judge. And, you know, there is in our system a decent amount of respect for verdicts and reducing them to judgment. I don't see any parallels, Your Honor, between us trying to move forward with Florida's well-established procedures for execution on a judgment and discovery and aid of execution, as well as putative proceeding supplementaries on these companies that they send their money to, and this newspaper article that he's raised here, which I haven't seen, but he's summarized enough for me to know what he's thinking. That being said, Judge, you used the metaphor goose and gander. We are, as of right now, a plaintiff with a verdict, and at some point, hopefully in the near future, a judgment creditor, and they are a judgment debtor. And the law is pretty clear on what a judgment debtor has to do, and they can't just say, you don't get discovery and aid of execution unless there's a stay or a bond posted to protect us in the event there's an appeal and so forth. And I know you know this, but I guess the point I want to make is whatever they file, I'm just knowing just generally the law on litigation funding as it exists throughout the state of Florida. We're going to look at it with an eye towards any basis we have for sanctions, for fees, or whatever, because at some point this just has to stop. We are not in the position of a defendant who has been found liable at a trial and who has been assessed a $140 million jury verdict, okay? There's a difference here. That's my point. And I say it now, Judge, because whenever they file this, if they file something, I want to be able to look back to this day and say, I told you so. Because I don't think there's any predicate for them to slow down collections in a case where they've been hit by a jury with a $140 million verdict, other than the numerous motions they filed today or that were heard today, the standard motions for minute a new trial and so forth that the court's already denied. That's all I have to say on that, and we'll wait to see what they file about whatever it is they see.
All right, so this order that was sent to me back in December that was in Mr. Gates' package, I'll sign this, I'll give you copies of this. I think the only relevant portion at this point in time is the paragraph 3, Gawker defendant shall provide to the document to the court for an in-camera review within 5 days. I mean, I don't know if it's 5 days.
The plaintiff asked us to bring a copy, and I have one. I'm just happy to hand it to you if you're going to issue that order so that there's no delay.
Oh,
So I have the document with me, and I'll be happy to give you a copy.
great, thank you. And then if the court overrules Gawker's privilege objection, orders production, such order shall be stayed for 3 weeks. And at this point, the timing's a little off, but I don't care about that part. Anything else rather than me giving you, other than me giving you copies of this order? Anything else that we need to talk about today?
Nothing here.
Your Honor, I just wanted to raise with you just so that there's an orderly process. At some point, I assume this last motion to dismiss and for the trial will be resolved by a judge. Then it would be appropriate at that point, based on Your Honor's proceedings today, the argument that you heard, I'm assuming at that point that we would then have a judgment that would be entered. At that point, we would at some point we would like to have a conversation with the court about a stay in the bond. I don't know if Your Honor wants to set a hearing for that, but I would like to have a procedure so that there's not a whole bunch of scurrying around with you and with the appeals court on all of this. And if there's some way to do that, it probably would make sense to understand what Your Honor envisions and to make sure we line it up. I'm trying to raise this so that consistent with what Mr. Turkel says, that we do that, in a deliberate and orderly fashion rather than, hanging out for a long time with that. I realize that part of that depends on, allowing some reasonable time to deal with the other motion.
Are we asking for?
I think he's asking for a schedule, a date.
Yeah,
That's what I think, yes.
just the schedule.
Well, let's start off with Tuesday. By Tuesday, May 31st, by the close of business on that day, I'm going to have the plaintiff's response to the motion to disqualify, and I'm having from both sides any supplemental memorandum brief that they want to submit in regards to entering a final judgment with a pending motion for new trial or, renewed motion for dismissal for fraud on the court, or alternatively amended motion for new trial. And let's just take a brief break really quick. I need to go get my trial calendar. I'll be right back.
All rise.
All right, so if everybody would look at their calendar for June 10th, Friday, June 10th. I'm so glad everybody's available. Great.
I'm sure.
Your Honor, just...
And Judge, we would be looking at that to set a hearing to clean up loose ends from today. We're looking at that date as a hearing date
Yes.
for whatever loose ends remain after today.
Yes.
Okay.
Your Honor, I was checking with Mr. Barrett. I am actually out of pocket from the 10th through the 17th. And I have sort of been dealing with these issues, so if it's possible to delay it 1 week, that would actually be very helpful.
It is possible.
If it goes if it goes much longer and you want to do it, then I think Mr. Barry will have to, if he's available.
That's the end of a 2-week trial docket. and I've got currently 3 trials, the longest being 8 days. So I figured one way or the other, probably that Friday, I've got some hearing time available. Otherwise, it goes back to my normal, just slammed calendar. So we're sort of putting the cart before the horse. So I think we first need to resolve the motion to disqualify, and then we'll see where the other things fall out.
Right.
So
I mean, the main thing I'm asking is to make sure that if there's going to be, it sounds to me like you're going to sort all this out, and that you know, on the 13th, we would be prepared to deal with entry of judgment, whatever's left of the injunction issue, and a request from a stay by the defendants. What I want to just confirm is that if it's going to happen before then I want to address with some.
some
I want
of
to
that
address.
may be addressing ahead of time.
I'm sorry.
Some of that may be addressing ahead of time.
Right. The piece that I'm concerned about is that if there's, I would like there to be entry of judgment at a time when we could be heard on a stay motion, or at least to have execution stayed until we can come back and be heard on that. If Your Honor's going to enter judgment before then. That's the piece that I'm focused on, and we will make it happen on the 10th if that's what fits in your calendar, Your Honor, of course.
Well, then I'd say it's probably on the 10th.
I don't know what Your Honor's envisioning, and you don't know.
I'm not really sure.
You're not
I'm
sure?
not really sure.
All right.
That's why I'm saying maybe we have the cart before the horse. If I'm not allowed to comment on one, and it's too interwoven.
I was assuming that it is planned that at some point, maybe by the 10th, that
Today we're not over?
I'm sorry?
Today we're not done? I understand we're not.
I was understanding that we would come back on the 10th and deal with judgment and stay issues. And the main thing I'm trying to confirm, and maybe the plaintiff has something he wants to say about this, I would like not to be in the position of having judgment entered with them trying to execute without having the opportunity to be before Your Honor on the question of whether or not we can have a stay with some appropriate amount of bond or security. So that's the thing. If we can all agree that that's what's going to happen, you know, at the 10th, then that will work. And if it's not, then we probably want to come up with some other plan so that we're not trying to do that while you're in the middle of the trial or something else where we can't put that issue in front of you and we're faced with the judgment without an opportunity to have the state transfer.
Judge, well, I mean, one, if that case, if the court actually can enter a judgment while there's a motion for new trial pending or this motion to dismiss pending, then we would offer you go ahead and enter the judgment and stay execution until the 10th, and then we can come here on the 10th and decide whether they're going to have some predicate to stay or have to post a bond, or can they post a bond. You know, I don't want to beat a dead horse, Judge, but the scenario has changed a little bit here. We actually have rights and we have reasons to not delay entry of judgment because they want to file motion after motion after motion. At some point it ends. At some point, you reduce it to judgment and you either bond it off or you suffer execution and appeal your case while you're being undergoing execution discovery. It's not that hard. It happens every day in the courts.
So it's not what Mr. Chappelle is sending you a little bit of a...
Olive branch, Judge.
I wasn't going to go that far, but some kind of a cushion. So...
Dental floss.
What I heard him
hanging off the
say,
cliff.
what I heard him say is, to the extent that Your Honor concludes that you can issue judgment before the 10th of June, he's agreed not to execute on that judgment until we can be heard on the 10th of June.
That's
on
all
the
I
stand.
heard.
We good with that?
And on that basis, I think we're all good.
All right. Great.
Thank you.
And Mr. Barry, you're available on the
Nothing is
10th?
unreasonable, sir.
I can make myself available.
Okay, wonderful. All right, so let's say then at 9 o'clock, not 9:30, 9 o'clock on June 10th, we'll start.
Aaron, did you pick up on that? Dental floss.
I got it here. Off the cliff. I got you.
I just thought that was particularly
Creative.
And Your Honor, would you like us to just take a moment and alter this other stipulated order and hand it up to your...
Yes, that would be great.
good.
Do you want... I don't think the code gets a new one. We don't have the Well, I just wanted to say, I'd like to just reflect on the record that I'm handing you a copy of the Mayor Brown report, which is for in-camera.
That's Mary name.
And they want you. How's that for quick compliance? You hand me an order, I hand you the document. Thank you.
And then I got, and then we can adjust this.
I'm waiting for the client. I might see you.
Sorry.
That's right.
One more so crazy.
No, I understand. That's why I asked you. Come on.
And then here, this is your original letter back. And then this is the revised.
So these are the exhibit lists that you believe were not received by the court and that you wanted back from the clerk at the end of the day.
No, those are the exhibits that actually were admitted to the court. We went through the transcript, you signed the law. Made our list, checked it twice and compared it. And basically saying, keep those, and the rest of it is not stuff like that.
Don't change it.
Do you have your copies of this? Hey, how about this? Take this back, redo it, and give it back to me. I would never sign it last page, especially in this case. It's just way too complicated. So somebody take this back and send it back to me.
We'll get it.
Properly formatted.
We'll get it over to you tomorrow.
Okay, so, anything else?
Let me just check it.
Okay.
No, we're done.
Anything else?
We don't have anything else, Ron.
All right, good.
Judge, the court, are you going to generate a notice of hearing for the 10th? Or you want one
I
else?
only generate orders.
Okay.
I don't generate notices. I generate orders.
Order
for
on case management, yeah.
I'll do an order on a case management.
We're happy to do something if you want, but I don't know if you were just going to do it.
No, I'll do an order for case management, and we'll see where we are at that point in time.
Okay, thank you.
Thank you all very much. Safe travels back to everyone. See you next time. Thank you. You're so quiet today.
And I've had other obligations.
I understand.
So that takes my separate.
Do we have a